Now we'll discuss in this video regarding sub-delegated legislation. So how sub-delegated legislation differs from delegated legislations. Sometimes the enabling act or parent act making delegation of the legislative power authorizes the delegate not only to make legislation or law but also to delegate the law-making power to other authority. This is called sub-delegated legislation or sub-delegation of the legislative power. Sub-delegation will be valid only when the parent act or the enabling act authorizes the delegate to delegate its law-making power to another authority or body. In short, sub-delegated legislation will be valid only if the delegate is given by the parent act expressly as it was held by the Supreme Court in Central Talkies versus Dwarka Prasad in 1961 or impliedly as it was held by the higher court in the leading case UP State Electricity Board versus Abdul Shakoor in 1981. The power to delegate the whole or part of the lawmaking power entrusted to it to any other authority. For example, where the Act contains the provision that no suit shall be filed for the eviction of a tenant without the permission of the district magistrate or any officer authorized by him to perform any of the functions assigned to him under the Act, and the permission is granted by the additional district magistrate on whom the powers were conferred. The order granting the permission will be valid as the Act expressly empower the delegate district magistrate for sub-delegation of powers as it was held in the leading case Central Talkies versus Dwarka Prasad in 1961. Essential Commodities Act 1955 may also be mentioned. The Essential Commodities Act 1955 as an example of sub-delegation. Section 3 of the Act confirms rule-making power on the central government, and Section 5 of the Act empowers the central government to delegate further this power to its officers or to the state government or the officers of the state government. So, sub-delegation can be made only when the parent act expressly or impliedly empowers the delegate to do so. If the parent act is silent on the issue, sub-delegation should not be made. And regarding Defense of India Act 1962, we would discuss the most important leading case, Harichandra Agarwal versus Bhatla Engineering Company Limited in 1969, where the Supreme Court held that the central government sub-delegated the power of requisition of property to the district magistrate under the Defence of India Act 1962. The requisition of a shop by the order of an additional district magistrate was held to be ultra-virus and invalid, as the additional district magistrate's status is not equivalent to the status of the district magistrate. There should be guidelines to be followed by the sub-delegate in the exercise of the powers entrusted to him by the delegate. If the parent act has laid down such guidelines, it is not necessary for the delegate to lay down any further guidelines. Publication of sub-delegate legislation is an important device to control it. In England, publication of delegated legislation is necessary for its effectiveness, but the publication of sub-delegated legislation is not necessary for its effectiveness. But in India, the position is different. It is now well settled that publication of delegated legislation as well as sub-delegated legislation is necessary for their effectiveness and validity. Publication of delegated legislation will be necessary for its validity and effectiveness even where the parent act does not specifically provide for its publication. If the parent act permits sub-delegation only through a particular procedure, the sub-delegation will be valid only if it has been made by following the procedure. When the sub-delegation is permitted only by making regulations, the sub-delegation will be valid only if it has been made by making the due regulation. So, it is to be noted that if the delegate has sub-delegated the power to an official or authority and has prescribed certain conditions to be complied with by the sub-delegate before the exercise of the power, the sub-delegate will be bound to comply with the conditions so prescribed, and if he exercises the power without fulfilling the conditions prescribed by the delegate, the exercise of the power by him will be ultra-virus and therefore invalid. For example, the central government subdelegates certain power to the state government subject to the condition that before making in the exercise of power delegated to it by the central government, the state government will obtain the concurrence of the central government. An order is passed by the central government in exercise as the said power, without obtaining the concurrence of the central government, the order will be ultra-virus and therefore invalid, as the conditions required to be fulfilled before the exercise of the power has not been complied with, as it is sub-delegated by the central government to the state government, and the condition of concurrence of the central government is a must, as the state government failed to get the concurrence of the central government as per the guidelines of the such sub-delegation by the central government. So it was held as ultra-virus and invalid without obtaining the concurrence of the central government. So this is what exactly called sub-delegation, and sub-delegated legislation is always made by the delegate or the delegated authority as provided under the parent or the enabling act, and those guidelines or criteria or standards as laid down under the parent or enabling act or by the so-called delegated authority or the executive to whom such power is delegated by the legislation. So, in this way, we found the very difference between delegated legislation and sub-delegated legislation. And in our next upcoming video, we would like to discuss the very growth of delegated legislation.